Hello and welcome to the Law Lab. Here we dissect and unpack everything legal. My name is Rhysa Iris Ewonia, and today I'll be taking you through leases, specifically termination of leases. We have previously discussed how leases can be created, the types of leases, their nature, and its features, which characterize what a lease is all about. And we've also touched on the terms and conditions, also known as covenants, in relation to leases. So today we'll be talking about how to terminate a lease. A lease can be terminated in many ways. Examples of the ways in which a lease can be terminated is when the lease expires, where there is a notice that has been given, or where one of the parties forfeits the lease, where the party surrenders the lease to the lessor, where there has been merger or frustration. The expiry or effluxion of time of a lease. Under common law, the lessor is entitled to automatic possession when a lease comes to an end, which is when the time has expired by reason of the covenants that have been placed in it. Typically, in leasehold agreements or landlord tenancy agreements, when the lease comes to an end, there's a reversionary interest that's attached to it, which states that when the lease comes to an end, the interest that the lessor has in the property reverts or it goes back to the landlord. So when the period within which you created the lease has expired, the lease will come to an end and the reversionary interest will kick in. The Rent Act we have in Ghana has, however, put some restrictions on the rights of the lessor to retake possession on the expiration of the lease. That is captured under Section 36 of the Rent Act, which I will explain further in the video. A lease can also come to an end when a notice has been served or a notice has been given. Where a lease makes an express provision for termination by notice, either of the parties can exercise that right by giving the requisite notice, and that is stated in the case of Savage and Gehawk. However, the length of the notice must be in accordance with the terms stated in the lease, and that was stated in the case of Allison versus Scargill. For notices on periodic tenancies, the case of Almedine Brothers and Patterson, Zokonis and Co. Limited explains further on it, so I encourage you to read that case for a comprehensive understanding. It's important for you to note that even though we are supposed to read these cases to understand how a lease can come to an end when a notice has been served, Section 67 of the Land Act 2020 Act 1036 talks about notices being served on the lessor or the lessor serving notices on the lessee to bring the lease into an end. Section 67 of the Land Act 2020 Act 1036 states that unless otherwise provided in a conveyance, a notice required to be given under the conveyance shall be in writing. So it's important for you to note that the notice to be served must necessarily be in writing. And A, the notice to the transferee is sufficiently served if I, it is delivered to the transferee personally, II, it is left addressed the transferee on the premises conveyed, III, it is sent to the transferee by registered post, IV, it is left at the last known address of the transferee in the country, and V, it is sent by secure electronic communication, where that is the mode of communication between the transferee and the transferor. However, another way in which the notice can be served is when VI states that in the case of a company, it is sent to the registered office of the company in the country. So based on these provisions, you understand that the notice to be served must be in writing and you must necessarily give it to the person that must be served. Or if it is a body, you must serve it at the registered office of the company or the organization. So you cannot state that you met the person at maybe a public place and you inform the person that you are bringing the lease to an end. You must give him a written notice and you must deliver it to the person personally, or you can send it either by post or leaving it at the registered office of the company, depending on the circumstances. Section 67B also goes on to say that a notice of the transferor is sufficiently served if I, it is delivered to the transferor personally, II, it is sent to the transferor by registered post, III, it is left at the last known address of the transferor in the country, and IV, it is sent by secure electronic communication, where that is the mode of communication between the transferee and the transferor. Or V, in the case of a company, it is sent to the registered office of the company in the country. So you must make sure that if you are bringing your lease or your landlord-tenant agreement to an end, you must serve a written notice to the person to inform the person of your intention to bring the agreement to an end. A lease, as I stated earlier, can also be terminated by forfeiture. The landlord has a right to forfeit a lease, and under the common law, this situation arises where A, in the event which has been expressly stipulated in the lease as terminating it, it has occurred. So if in your leasehold agreement, there was a particular covenant which was expressly stated in it that if that particular covenant has been breached, the lease will be forfeited. When that occurs, the lease will be said to have forfeited under the common law. And also, when the tenant has breached a condition in the lease, but that is subject to statutory restrictions, which I refer you to sections 50 to 52 of the Land Act 2020 Act 1036. I encourage you to read these particular provisions for a comprehensive understanding of covenants in relation to leases and how, if you fail to observe these conditions or these promises you have intended to fulfill, it can bring your agreement to an end. The cases of Saki and Ishon, Basso and Said Rad, and Asante versus K Compute Services Limited speak extensively about how a lease can come to an end through forfeiture. So I encourage you to read these cases. Where the lessee denies the title of the landlord, it gives the landlord the rights or the automatic right to forfeit the lease without any statutory restrictions. And that was stated in the case of Safo and Bedu, which I encourage you to read. However, the landlord has a right to assert his right to forfeit the lease if these particular conditions has been met or it has been breached, depending on the circumstances. It has, however, been held that the usual practice is for the lessor to sue for recovery of possession, as was stated in the case of Interplus versus Bonsu. For forfeiture of leases, Section 57 of the Land Act 2020 Act 1036 gives a comprehensive understanding of what must be met for a lessor to forfeit the leasehold agreement. Section 57(1) states that a right of re-entry or forfeiture under a provision in a lease for a breach of a covenant, condition or agreement in the lease is not enforceable by court action or any other means unless A, the lessor has served on the lessee a notice. So the notice I made mention of under Section 67 of Act 1036 must necessarily have been served on the lessee by the lessor to ensure that indeed the lessor has a right to forfeit the lease by way of a court action. After he serves the notice, he must make sure that in the notice he specifies the particular breach complained of, and also he requires the lessee to remedy the breach if the breach is capable of being remedied. So for instance, there is an implied covenant on the lessee to ensure that he repairs the property for any injury or damage he causes to the property. So if the lessee fails to do this, the lessor can serve the written notice on the lessee to ensure that he fulfills his promise to repair the property for any damage he causes to the property. So in this instance, if the injury or damage he caused to the property is one that is capable of being remedied, in the notice, the lessor must inform the lessee that he must remedy the breach to prevent him from forfeiting the lease. Also, in the notice, he is required to inform the lessee to make reasonable compensation in money for the breach, except where the breach consists of non-payment of rent. So sometimes some people will decide that under certain circumstances they wouldn't want to pay rent, or maybe they don't want to fulfill their obligations under the lease. If the lessee fails to do this and the landlord decides that he wants to fulfill the lease, he must serve a notice on the lessee and he must require him to pay reasonable compensation for the breach he has occurred, unless the compensation is by way of paying a rent, in which the law will not enforce. Under Section 56(1)(b), it states that the right of re-entry or forfeiture of the lease, which can be exercised by the lessor, cannot be done by enforcing a court action unless the lessee has knowledge of the fact that notice has been served on him, and C, the lessee fails within reasonable time after the service of the notice under paragraph A to remedy the breach, if that breach is capable of being remedied, or to pay compensation to the satisfaction of the lessor for the breach, or in the case of non-payment of rent, to pay the rent and interest on the rent at the prevailing bank rate. Subsection 2 of section 57 goes on to say that where a notice is sent by registered mail addressed to a person at the last known address of the person or by electronic mail, where that's the normal mode of communication between the parties, and B, it is posted on the land which is subject of re-entry, then for the purposes of subsection 1, the person shall be deemed, unless the contrary is proved, to have knowledge of the fact that the notice has been served as from the time at which the mail would have been delivered in the ordinary course of post, or the notice was posted on the land. What this whole provision is talking about is, if between the lessor and the lessee, they typically communicate by using email or whatever mail address, and the lessor, in deciding to forfeit the lease, he decides to send a written notice to the lessee through mail. The lessee will be deemed to have received notice of the lessor's intention to forfeit the lease and to also re-enter his own land if he would have received the mail at the time that he ordinarily expects to receive that mail. So I encourage you to read section 57 extensively to get a comprehensive understanding of how leases can be terminated through forfeiture. However, even though the lessor has a right to forfeit the lease, the lessor may waive his right under certain circumstances. The waiver must, however, be related to a particular breach, and it is not continuous. So if you failed to fulfill your particular covenant under the landlord-tenant agreement, maybe you were supposed to repair the property and you failed to do that, and the lessor waived his right to re-enter the land and forfeit the lease, it doesn't mean that if you breach another covenant, that same waiver will apply. It is not a continuous thing, as was stated in the case of Matthews and Smallwood. So I encourage you to read that case. The waiver by the lessor must, however, be given expressly or implicitly. The court can, however, decide to grant a relief against forfeiture to a lessee or a sub-lessee, depending on certain circumstances. The case of Asante versus K Compute Services Limited talks about this extensively, so I encourage you to read that case. A lease can also be terminated through surrender. Surrender occurs when the lessee yields up his interest in the property, or he yields the residue of his leasehold interest to the lessor. So maybe the lessee has been on the property for about 15 years and there's a remainder of 10 years, and he decides to surrender the remainder of the interest back to the lessor. It will bring the leasehold agreement to an end, so there will no more be existing a landlord-tenant agreement. The leasehold interest and the reversion thereby will merge to the landlord when the lessee surrenders his interest, and the lease will be said to have extinguished. A lease can also be terminated through merger. Merger occurs when there is a union of the lease and the reversion in the lessee. The lease is thereby extinguished when that situation occurs, and it will contrast with intervening interest, which in this case could be a sublease. There's a general principle that leases cannot be frustrated. Frustration in contract terms is an unforeseen circumstance or something that is not within your control, which occurs, which renders you unable to enforce your contract. So it is generally believed, or it's a general principle, that leases cannot be frustrated. There is therefore the need for the parties to ensure their interests to cater for any frustrating events, in quote. However, the parties may also put in the agreement clauses that may lead to the suspension of obligations in cases where certain unforeseen events do occur. That was explained in the case of National Carriers Limited versus Panalpina Limited. Because a payment of rent is a necessary condition that exists within leasehold interest, it is important for us to address the law that talks about rent in Ghana. And in our case, it's the Rent Act 1963 Act 220 or Act 220. The Rent Act has placed several restrictions on the recovery of possession of property. And this particular act states under Section 17 of the Rent Act 1963 Act 220, it states that for all premises that are subject to the Rent Act, for a landlord to recover possession of the lease premises, he must, in addition to his right to terminate under common law or any other enactment, find an additional ground under Section 17 of Act 220. Section 11 gives us particular premises within which the Rent Act applies to, and it states that all premises in Ghana are subject to the Rent Act, but it gives exceptions under Section 12 to include a public officer being a tenant with the government as a landlord. So if you're a public officer that is staying in the state housing premises, you are not subject to the Rent Act that we are talking about. Also, if you lease a bare land or a lease of premises which was demolished and another has been constructed within 5 years of the lease, it is not applicable to the Rent Act. That was stated in the case of Tego versus Mobil Oil Ghana Limited. Concessions, which are typically mining agreements, are not applicable, or the Rent Act does not apply to these particular agreements. Also, where government buildings rented out which have been certified by the minister that it yields no financial gain to the government, it is not applicable to the Rent Act. Where the government or council creates a market stall and it is owned by the council or local authorities, the Rent Act is not applicable to these premises. So these are the premises that have been excluded from the Rent Act. However, all other premises found within the country are subject to the Act, and Section 17 gives the grounds for recovery of possession under the Rent Act. Section 17(1)(a) says that arrears of rent for 1 month or one more are subject to subsection 4, as was stated in the case of Charles Oklu and Che. Section 17(1)(b) goes on to say that a breach of an obligation of the tenancy, with the exception of rent, can cause grounds for a landlord to recover possession of his property under the Rent Act. Also, where there's a nuisance by the tenant to the property or any other person residing with the tenant. So if you, the tenant, you are not necessarily causing the nuisance, but maybe your spouse or your friend or your child is living with you, and any of these people are causing the nuisance to the property and to your landlord, it will be grounds for the landlord to recover possession of his property. Section 17(1)(d) goes on to say that when there has been conviction for the use of or conviction for allowing premises to be used for immoral or illegal purposes. In Ghana, it is illegal for a person to use his premises for prostitution. So if you rent an apartment for about 10 years and you inform your landlord that you will use the apartment for residential purposes, but within the 10 years, you decide to gather prostitutes and use it for your prostitution purposes, it is an illegal thing you are doing, and it is grounds for, or it forms ground for your landlord to recover possession of his property and terminate the landlord-tenant agreement. Also, if you cause deterioration of the premises as a result of waste by you, the tenant, or any other person residing with you, it is grounds for your landlord to terminate the agreement. If the tenant, in giving notice of his intention to quit, and the landlord, based on that notice, contracted to sell or let the property to another person, it is grounds for the landlord to recover possession of his property. Section 17(1)(g) of the Rent Act, Act 220, goes on to say that premises required by a landlord for personal occupation as a dwelling house by himself, a member of his family, or a person in his whole-time employment is grounds for recovery of possession of property. So where the landlord has given his house to you for a period of time, and within that period, he desires to recover the land or the house from you and use it as a dwelling house for himself or a member of his family, which could be his wife or child, it is grounds for him to recover possession of the property. However, you must read this particular section in conjunction with Section 67 of Act 1036, which says that the landlord must serve written notice. So when he's serving the notice, he must indicate the reasons, and the notice must capture the reasons for which he wants to recover the property. Section 17(1)(h) says that where a lease expires and the landlord reasonably requires the premises for his own business purposes, not less than 6 months, notice in writing to the tenant of the landlord's intention to apply for an order for recovery of possession must be given. That was stated in the cases of Labi and Akwa and Barno versus Appa. If the landlord desires to recover possession of his property for business purposes for a period not less than 6 months, he must give notice to the tenant of his intention. Where a tenant has ceased to be in employment of the landlord, if premises was let by reason of employment, in the case of Ampoma and VRA, it is grounds for the landlord to recover possession of his property. Where the landlord personally in occupation and lets premises substantially furnished for a term during his absence and has returned and requires the premises for his reoccupation, it is grounds for him to recover possession of his property. All of these provisions under section 17(1) of Act 220 gives grounds for the recovery of possession of property. Under section 17(2) of Act 220, where the lease expires, a tenant or statutory tenant and a landlord who has the intention to pull down the premises and construct new premises, intends to remodel the premises subject to section 18, requires premises to carry out a scheme of redevelopment, not less than 6 months notice must be given of his intention. If there is a condition that if no such redevelopment is carried out within a reasonable time, the tenant should be reinstated as a statutory tenant on the property. The tenant, however, has a duty to monitor the progress of work, as was stated in the case of Ose and Anoche. Under Act 220, a statutory tenant has been explained, or a definition has been given of who a statutory tenant is. And I encourage you to read section 36 of Act 220 very well to understand who a statutory tenant is and how such persons should be treated. Section 36 defines a statutory tenant as a tenant who remains in possession of premises after the determination by any means of the tenancy and cannot by reason of Act 220 be deprived of possession by the landlord. Or, on the commencement of Act 220, is in possession of premises of which the tenant retained possession prior to the commencement by virtue of any enactment repealed by Act 220, or is a tenant by virtue of section 17(7). Statutory tenants typically, when these conditions have been met, there are certain rights and obligations that they must fulfill. Even though a landlord owns his property, and you would expect that as the owner of your own property, you have the right to enter into the land at any time to do what you want, the law has placed certain restrictions on you, the landlord. So if a person, by reason of his failure to pay rent at the time you're expecting it to, and the person becomes or assumes a position of a statutory tenant, it doesn't automatically give the right to the landlord to recover possession of his property. It can be done under certain circumstances, however. As I stated earlier, statutory tenants have rights and obligations, and they have the right to hold the premises as a tenant from month to month on the same terms and conditions as the expired tenancy, and that is touched on in section 29 of Act 220. They also have the right and obligation to not sublet without the prior consent of the landlord. The landlord under the Rent Act, however, has a right of distress for arrears of rent. Statutory tenant cannot demand a premium as an inducement to give up possession of property, as stated in section 28 of Act 220. So, even when you fail to pay your rent at a certain time, it does not necessarily automatically mean that the landlord can enter the land and sack you from the place you are staying. That attitude of landlords is not recognized under the law. Before the landlord can recover possession of his property, he must serve you a written notice, and if it's a breach that can be remedied, you must necessarily remedy it. If you fail to do that, it is when the law will recognize that the landlord has a right to bring an action in court for the recovery of his property and to re-enter his own property. Section 25 of Act 220, however, talks about general offences that can be committed in relation to the property. If the landlord demands or receives more than recoverable rent, he's demanding a premium, he's receiving more than 5% of recoverable rent for a year as an agent, he demands more for furniture, fittings, or fixtures where such articles are conditions for grant, he enters into an agreement with the intention of defeating purposes of the Act, he fails to furnish information required to be furnished as an LL under the Act, then the landlord has committed these offences. The offences are captured under Section 25 of Act 220, so I encourage you to read it. By way of recap, I talked about certain factors which can cause for a lease to be terminated, and I gave examples to include the expiry of the lease, when notice has been served, when there has been forfeiture, surrender, merger, or where there has been frustration on the leasehold agreement. I hope you have understood these conditions extensively and you'll be able to apply it in your everyday life. Thank you for joining us in this wonderful session. Please do not forget to like, comment, subscribe, and share our videos to your friends and your peers for them to learn and understand the conditions under which a leasehold agreement can be terminated.